Good afternoon, everyone. After again 1 month, we are having our study circle meeting today, 6th study circle meeting on the topic of recent highlights of indirect tax in recent budget finance 2023 by Advocate Monarch Bhatt. Now, before introducing our speaker today, I would like to thank Monarch Bhatt for showing his vigor and commitment and dedication on giving lecture today, despite losing his father just few days back. And we really appreciate that, Monarch Bhatt. And thank you for making it your time available over here for the association. At the same time, we would like to now first remember the lost soul, Mr. Mahendra M. Bhatt was member of this association, and he has given immense contribution to this association and all other associations in Bombay. And in his remembrance, we would first like to have 2 minutes silence. May I request everybody to observe 2 minutes silence for Shri Mahendra Bhai M. Bhatt. Om Shanti. Now, may I introduce our speaker today, Shri Monarch Bhatt. I think we all must be knowing him. He is already a member of our managing committee since last 2 years. He has been contributing regularly in GST review by various publications, as well as by giving lectures in intensive and study circle meetings. He is into practice since last 15 years in indirect taxation, currently working as a partner with Fair Law Firm and as an associate of the SS Gupta, CA. Monarch has authored e-book on various GST topics, and he is also a regular column writer in various online portals, journals, etc. He has been conferred with the Best Speaker Award for Intensive Study Circle 2021 by GSTPAM. And he is one of the leading and pioneer practitioners in the field of GST in the upcoming future. With this brief introduction, may I ask everybody to welcome Monarch Bhatt with a live hand. Today's topic being highlights of indirect tax in this recently concluded finance budget 2023. There are a lot of expectations by the businessmen and the members of the association and the practitioners in general. I think this budget may not have come true to all the expectations, but we'll keep the conclusions at the end after listening to Monarch Bhai on the topic, and then I'll request everybody to come up with suggestions and your problems which you are facing in daily practice of GST, which we can represent to the authorities. I hand over the mic now to Shri Monarch Bhai for speaking. And before that, may I request our President, Shri Sunil Kushlani ji, for handing over a memento to our today's speaker. May I request Sunil Kushlani to give opening remarks for today's session.
Dignitaries on the dais. You can see the commitment of our member towards the GSTPAM. See, when Monarch's father passed away, we were discussing we have a study circle meeting on so date, and 12th day will not be passed 12th day will not be over. Normally, we don't do any activity up to 12th day. But this was the commitment which Monarch Bhatt has shown. It's really commendable. I thank Monarch for showing the great commitment towards the association. And today, Monarch is going to speak on the subject of suggestions and corrections, suggestions and budget proposals. Hope, see, one cannot satisfy everyone. They have put forward the suggestions, but it is not always possible to satisfy every person or every industry. So let us see the proposals given by the finance minister in the budget 2022-23, and he will explain us. Monarch will explain us the intricacies of this budget. Hope everybody will be satisfied with that, and I request everyone to come forward and raise the questions so that we can understand the budget in a better way. I now request Monarch to start the session. Thank you very much. Thank you.
Yes. Yes.
Good afternoon, friends. At the outset, I am thankful to the association for giving a respect to my late father by keeping a silence for 2 minutes. And I also thankful for the words of sympathy from each and every member of the association we have received. Now, friends, today's session highlights of indirect tax proposals, which has been pronounced in the Union Budget 2023. Friends, as most of the people were expecting the amnesty scheme, so that has not been announced in this. Let me tell you in the beginning, so that you should not wait till the end of the presentation for that amnesty scheme. So there is nothing as such in the amnesty scheme which has been announced under the indirect taxes, even under the erstwhile regime or under the GST. So friends, we will be discussing what has been given with relation to indirect tax, especially GST is concerned. So let us begin with the session. Friends, let us go back to the basics of how the finance bill has been presented. There are 154 clauses are there in the finance bill. First is, of course, short title and commencement, clause 1. Clause 2 is with relating to rates of income tax. Thereafter, clause 3 to clause 122 is with respect to the income tax. And clause 123 to 127 is for customs and customs tariff. And from there onwards, indirect tax proposals starts from clause 123. CGST and IGST provisions are contained from clause 128 to clause 144. And miscellaneous clauses are there under clauses 145 to 154. So friends, first of all, whenever finance bill gets introduced, very important is when all these provisions will come into effect. That is the very important part. So let us come to the first clause, which says that short title and commencement may be called the Finance Act 2023, and sections 2 to 122 shall come into force on the first day of April 2023. This is clause 1, talking that section 2 to 122. So it is 2 to 122 means rates of income tax and income tax provisions will come into effect from the 1st April 2023. Now, it nowhere mentions about any other provisions. So we can say that all other provisions will come into effect from the date of enactment of the finance bill, unless explicitly provided in the bill. So once I say this, now let us what happens under the budgetary provisions we have seen over the period of 5 years now, that how GST budgetary provisions becomes an act. So first it happens with the presentation of finance bill, then presentation before each of the house and assent of the president. So there can be some of the provisions which comes into effect from the date of assent of the president. And simultaneously, there has been amendment has been made in state statute. So accordingly, thereafter, it gets notified by synchronization of CGST provisions as well as the state act provisions. Now, when there is no such specification has been provided as far as indirect tax provisions are concerned, as per the current finance bill, it happens to be that the date when it receives the assent of the president, all these provisions will come into effect, irrespective whether there has been changes has been made in the state act or not. So that is the current provisions. So the question is that I have already dealt with, that GST provisions coming into effect from the date of enactment of finance bill. So yes, from looking into the wordings of clause 1, it seems so. But if it happens, then there won't be any synchronization with the central and state levies. So generally that should not happen. And therefore, I feel that all these provisions will come into effect after enactment of the finance bill from the date to be notified. And why this? Because see friends, this is a finance bill which has been presented. And in the bill, they can always amend the things till the time it becomes the act. So when they are coming up with the act, I'm sure that they will insert one more clause B in subclause 2 of section 1, which is proposed finance bill, which is in the history also we can see that in each of the finance bill, there is a section, there is a clause 1 subclause 2 of clause B, which provides specifically the date of enactment of the GST provisions and indirect tax provisions, which is missing somehow in this finance bill, which will be introduced when they are coming out with the Finance Act. So that is one thing, and the analogy can also be drawn from the TRU, which has been issued by the board. They are also saying that all these GST provisions, unless explicitly provided, that is clause 142, which is the retrospective amendment, will come into effect from the date to be notified after enactment of the finance bill. So we can say that it will come into effect from the date to be notified after enactment of the finance bill. So friends, I have dealt this issue in detail because this is very important one, and there are a lot of interpretational issues are going on as far as enactment of the proposals are concerned. Now, friends, we will be discussing with the amendment what has been proposed in the finance bill as far as GSTs are concerned. First is with respect to the composition levy, whereby what happens as of now, that if you are making any supply of goods or services through electronic commerce operator, then you are not entitled to go for the composition scheme. Now this has been done away, and it has been proposed that even if you are dealing into the goods and you are supplying to the electronic commerce operator, then also you can go for the composition scheme. So that has been very good proposal as far as dealers are concerned for opting of the composition scheme. So this will encourage the dealer to go for the composition scheme, because nowadays, see friends, law is always evolving law, and nowadays we can see that most of the transactions are happening through e-commerce. So it is very essential to provide such type of dealer the benefit of the composition scheme. The same has been proposed by doing this deletion of the word goods. Of course, rest all conditions remain same, which needs to be satisfied by the assessee to opt for the composition scheme. Turnover limit and everything remains same. So at other places as well, they have made the same amendment, so they can go for the composition scheme wherever, even though they are providing a goods to the electronic commerce operator. Yes, I have already dealt with this. Now, friends, another proposals are with respect to the input tax credit. It is always the area of amendment in each of the finance bill. So, first amendment has been proposed under section 16, which provides that what is the eligibility and conditions for availment of the input tax credit. There are various conditions has been provided for taking of the input tax credit. One of the core condition is that you need to make the payment within a period of 180 days. And if payment has not been made, then you need to reverse along with the interest. And once you make the payment, then you can take the credit of that. That is what the provisions is all about. Now, friends, when it was introduced, that time we all are aware that there were a system of GSTR 1, 2, and 3, which never got implemented. And therefore, when it never got implemented, what happened? That those statutes provided that when payment has not been made within a period of 180 days, it is to be added to the output tax liability and interest is payable on it. It never happened. What assessee used to do, they used to reverse the credit and they were making the interest payment if it goes beyond 180 days. So now with this amendment which has been proposed, the same has been made incorporated into the act itself, that yes, instead of adding it to the output tax liability, it is to be reduced from the input tax credit. That is what has been proposed. So it is aligning with the returns system of the GST, which is currently prevailing. And also the another amendment which has been made in the proviso to that particular clause, which says that provided also that the recipient shall be entitled to avail the credit of input tax on payment made by him to the supplier. They have added to the supplier now. Now, of course, we can say that yes, payment is to be made to the supplier only. Then only you can take the credit. That is fine. In 90% of the cases, that is happening and that is fine. But in some of the cases, like if company goes into the liquidation or something, then that payment directly goes to the IBC. So in those type of situation, it may create certain ambiguity as far as this phrase which has been proposed to be incorporated in the finance bill. So there you need to argue out that to the supplier is as good as the payment to the IBC, because under that provision, the payment has been made. And therefore, ultimately it goes to the supplier only. But however, it will create a litigation. That is what we anticipate from this. So that is one of the area when we are dealing into all such type of cases. We can keep those areas into our mind. So this is one of the proposal which has been made. Now, yes, we have already discussed this. Another amendment, there are two amendments has been proposed in the input tax credit itself under section 17. Section 17 provides for the apportionment of credit and block credit, right? So what credit is to be taken? What is the block credit? All such has been provided under section 17, right? So friends, subsection 3 provides that when you are supplying exempt supply as well as taxable supply, which is and the input or goods or services or both is the commonly used for those purposes, then whatever is attributable to the exempted supply is to be reversed proportionately to calculate the what is the taxable ITC available with the assessee. So there are formulas has been provided under Rule 42 and Rule 43 for ITC and capital goods. So now friends, I'm not going into the debate that whether subclause 2 provides for this and 3 later on provides for the valuation, how to do the valuation for exempted supply and all such things. Those are the different level of argument. But as far as this amendment is concerned, what it says that in the explanation for computation of exempted supply, as of now, you need to take into consideration where the amount is towards reverse charge mechanism. Then that is to be considered as an exempt supply. Transactions in securities, transactions in sale of land, of course, where you are making a tax payment on the buying of flat prior to occupation certificate is not to be considered as an exempt supply. So all such transactions is to be considered as an exempt supply. Now it says that as per this, explanation has been added, and it says that the value of such activities or transaction as may be prescribed in respect of clause A of paragraph 8 of the said schedule. So that is to be considered as an exempt supply. Now, what is clause A of paragraph 8 of schedule 3? Friends, schedule 3, we all are aware, which provides for the activities or transaction, which is neither to be treated as supply of goods nor to be treated as supply of services. Right? So, paragraph 8 is with relation to bonded warehouse, where from the bonded warehouse you are supplying any goods. So it is outside the purview of GST. It is not to be considered as supply of goods nor as a supply of services. Fine, perfect. That is what required. Now what it says, that though it is not supply of goods or supply of services, means it is not a supply under the GST, but for computation of input tax credit eligible to the assessee, you need to treat it as an exempt supply. So can the statute goes beyond their own provisions, where it says on the one side that it is not to be treated as a supply at all, and for computation of exempt supply you are saying that it is to be treated as a exempt supply. So in my view, that is a very litigative area, and it is ideally, legally, it is not to be treated as a exempt supply. However, it has been proposed that while doing the computation, whatever supply made from the bonded warehouse is to be considered as a exempt supply, and while calculating the ratio, to that extent your input tax credit should get reduced. So now with this proposed amendment coming into effect, your credit will get reduced if you are having such supply towards from the bonded warehouse. Though it is outside the purview of GST, but for this purpose, it will be to be computed as an exempt supply. This is as far as first amendment is proposed under section 17. Now, another amendment has also been proposed under the same section 17, where subsection 5 of section 17 is the notwithstanding clause, which provides number of activities which is to be considered as a block credit, and for that assessor is not entitled, taxpayer is not entitled to take the credit. Now in that subsection 5 of section 17, one more clause has been proposed to be added, and that clause is FA, which reads as goods or services or both received by a taxable person which are used or intended to be used for activities relating to his obligations under corporate social responsibility referred to in section 135 of the Companies Act 2013. So friends, the new clause has been proposed to be inserted in section 17(5) to disallow or to block the credit of goods or services or both used for providing the CSR activities. Corporate social responsibility is the CSR activity. Now the question arises with this proposed amendment. Can we say that CSR is eligible from the date to be notified after enactment of the Finance Bill 2023? Answer is no. That once it gets implemented, thereafter taxpayer will not be entitled to take the credit of CSR activities unless there is another round of safari retreat happens, where in the case the matter is pending before the Supreme Court. So if you are challenging the introduction of provision itself, then it is altogether a different story. But as per the proposed provision, it is to be considered as a block credit. Now, another question arises that what is to be done if you have already taken the credit of CSR activities which is taken before introduction of this proposed provision. So friends, we are of the consistent opinion that CSR is in the course or furtherance of business. There are many decisions in the income tax, which is the direct tax provisions, which says that CSR is nothing. CSR is nothing, but it is helps the company to build his reputation and brand image and goodwill, which ultimately in a longer run gives profit to the company, which is the sole motto of incorporation of the company. And therefore, it is in the course or furtherance of business. And hence, it is eligible credit. Another ground, even in the case of GST, in the case of advance ruling of Dwarikesh Sugar, they have allowed the credit of CSR. Of course, there are advance ruling as well. There is a decision of the erstwhile regime of SL Propec as well, where it says that CSR expenditure is eligible as a SENVET credit under the service tax regime. So all these grounds can be taken as a basis for claiming the credit till the time it comes into effect. And another important ground is that this provision is coming into effect prospectively. It is not coming into effect retrospectively. And therefore, if intent was to disallow the credit since beginning, then they would have made it retrospectively. However, they have proposed this as a prospective amendment, and therefore that is also added ground that till the date it comes into effect, CSR credit is eligible. Of course, department won't accept all such things and it is to be litigated, but it is a good case to argue it out. So friends, this is with respect to the proposals made as far as input tax credit is concerned in the Finance Bill 2023. Now, another issue was there with respect to the registration of persons. Friends, section 23 provides that persons who are not liable for the registration under the GST. So there it says that yes, if you are providing an exempted supply, then you are not required to take the registration and agricultural list and all such things. So fine. But what happens if such supplier of exempt services or exempt goods is taking the services from the advocate, which is under the reverse charge mechanism? I am just giving you a hypothetical example. So if he is receiving services or goods, which is specified supply under section 9, on which reverse charge is applicable, whether he is required to take the registration, that was the main issue which all the assessors were facing. So now they have proposed to amend this section with the non-obstat clause, stating that notwithstanding anything to the contrary contained in subsection 1 of section 22 or section 24, where section 22 provides that you should take the registration and 24 provides that compulsory registration. So this section 23 will override both of that section. And in all such cases, if you are providing an exempt supply, then you are not required to register. So this will a welcome move. This will help to a greater extent. And one more question we can say, that what about the taxpayers who has already paid by having a conservative approach? can they apply for the refund of taxes? Because this provision, it has been specifically mentioned, this will come into effect from the first day of July 2017. So from the 1st July 2017, it has been made to be amended. So it is retrospective amendment. So those who have paid the taxes, can they go for the refund? Friends, explicitly, there is no mention in the finance bill that they cannot go for the refund. So as far as reading of the finance bill is concerned, I am of the strong opinion that they can go for the refund. Of course, there are other grounds can be taken into consideration where even as per the constitution, when there is no tax, you cannot collect a tax without the authority of the law. So once it was not a tax, government cannot keep it with themselves. So even for the time barring, it can be argued, which is the time barring is a 2 years period for the GST thing. That can be argued that since it is not a tax at all, that time period of 2 years is not applicable. And even for a period beyond 2 years, you can file a refund. So that is one way of argument. Of course, there are adverse decisions as well, where it says that no. Even though it is not without this, there is a decision in the favor as well as against, where it says that time limit shall be applicable. But if amount is sizable, one must go for the refund. And another question, if there is any objection has been raised during the departmental audit on such type of issues, even though when it has not been made effective, can you take the shelter of this and say that yes, it is not, tax is not payable in such type of situation? Of course, you can take a shelter of this because finance bill has already been presented and it is going to be implemented soon. So more or less department people may also will understand this. So this is with respect to the amendment proposed as far as GST registration is concerned. Now, friends, another amendment has been made as far as return filing is concerned, wherein there are 4 amendments has been proposed for section 37, section 39, 42 and 44, which provides for the filing of various type of returns and statements. So now what has been proposed in the finance bill, that a person shall not be allowed to furnish the details of outward supply beyond a period of 3 years from the due date of furnishing the said return. So from the due date till the time 3 years is there, you can file the return, but not beyond 3 years. Now, friends, many of the cases it happens that when due to non-filing of the returns, registration gets cancelled. And assessee approach is the writ court for this. And in the litigation, it may take more time than the period of 3 years. So what is to be done in this type of situation? So to overcome such type of situation, proviso has been added, whereby it says that government on the recommendation of the council by notification, subject to the conditions and restrictions as may be specified therein, allow a registered person or class of registered person to furnish the details of outward supplies for a tax period under subsection 1, even after the expiry of the said period of 3 years from the due date of furnishing of the said return. So council can make a recommendation by issuance of notification for such type of persons or a class of persons, and they can be allowed to file a return even after a period of 3 years. So the proviso has been added for all such type of cases. Now, with this similar provision has been proposed under 39, 44 and 52. So friends, section 37 provides that you can file the GSTR1. 39 deals with filing of GSTR 3B, GSTR 5, which is for the non-resident taxable person. GSTR 6 is for the ISD and 7 for the TDS. So there also similar amendment has been proposed that within a period of 3 years from the due date of filing of the return, they can file the return. And so that credit can be taken or anything which is missed out, they can do so within a period of 3 years max, not beyond that. And beyond that is there, then it is as per the recommendations of the council by issuance of the notification. Similar provision has been proposed under section 44 for filing of the annual return. So now for filing of any of the return, there is no time limit. You can file it for any time. Even now you can file for the 17-18 by making a late fees payment and all such things. But once it gets implemented, within a period of 3 years, you need to file the return. And if unable to file, if there is a genuine difficulty, then you can approach the commissioner or writ court. And thereafter, GST council can recommend that, okay, you are allowed to file the return. Then only you can file it. So this is with respect to the time limit for filing of the returns are concerned has been proposed. Now, friends, refund is always a hot topic. And similarly, in this finance bill as well, they have proposed some amendment as far as refund of tax is concerned as provided under section 54, which says that what is provisionally accepted ITC is not to be taken into consideration for granting of the 90% of the credit. So that has been proposed. That is the one thing. And it is a good thing. Even under the previous regime, there was no such thing for allowing of credit on the provisional basis. So that is one thing. And another thing has been proposed under section 56 for interest on delayed refund. Friend, there it says that for the period of delay beyond 60 days from the date of receipt of such application till the date of refund of such tax to be computed in such manner and subject to such conditions and restrictions as may be prescribed. So friends, it says that if the refund has not been granted within a period of 60 days, then you are entitled to the interest. It was there previously as well. No such big thing. But where the main important part is that in such manner and subject to such conditions and restrictions as may be prescribed. So one can hope that conditions and restrictions will be prescribed for this purpose. Now, generally what happens, friends, that when you are filing RFD1, you are getting the RFD2 if you are lucky. Okay. So that is acceptance of your refund application. And if not, then they are issuing the deficiency memo under RFD 03. So what happens that when deficiency memo has been issued, in many of the cases, they are saying that the original date when you had filed the refund application shall not be taken into consideration, and fresh application when you are making the refund application, after that issuance of deficiency memo, that is to be considered as the date of filing of the refund. And in many of the cases, they are arguing that Now, where the refund has been filed at the end period of 2 years, they are alleging that now the refund is time barred. Because when you filed it, it was after the deficiency memo, and prior to that, it was not filed by you. So there are the decisions which says that original refund application shall be taken into consideration for considering the time period of 2 years. Similarly, for computation of interest of 60 days, they are saying that yes, it is to be counted from the original date of refund filing. Now, the same has been proposed in the provision itself, where I feel that conditions will be such that in peculiar situation where the department cannot compute the refund itself, in those circumstances only it will be counted from the fresh refund application. In all other cases, one can be hopeful with this proposed amendment that in all other cases, original filing of the refund application will be considered as the date of filing of the refund application. And if you are not getting a refund within a period of 60 days, then from the 61st day, you will be entitled to get the refund of this, interest on this. So this is also a welcome move, which was very much needed. Now, friends, we are coming on to the proposals as far as penalties are concerned. Now, we have seen that a composition scheme has been provided to the supplier of goods who is supplying goods to the electronic commerce operator. They have been made eligible to go for the composition scheme. Now, to regularize this, they have proposed an amendment in section 122, which provides for the penalty, where new subsection has been proposed to be inserted, which says that any electronic commerce operator who allows the supply of goods or services or both through it by an unregistered person other than a person exempted from registration, then in such cases, electronic commerce operator shall be liable to a penalty of 10,000 rupees or an amount equivalent to the said supply. So the electronic commerce operator has been made responsible for this. Another situation they have provided that any electronic commerce operator who allows an interstate supply of goods or services or both through it by a person who is not eligible to make such interstate supply. We have already seen that this has been provided in the composition scheme, that they can supply to the electronic commerce operator. So now responsibility has been kept on the electronic commerce operator that if there is any failure, then he will be liable for a penalty of 10,000 rupees or tax payment, whichever is higher. And similarly, if he fails to furnish in his statement that he has received such goods from such supplier, then also the same penalty is payable by the electronic commerce operator. So friends, ultimately, one can sum up when we read out this proposed amendment in section 10 for the composition scheme and penalty provision under section 122. It is practically no electronic commerce operator will go for the such type of registered person, because why he will bear his burden? He will not bear his burden. So what I feel that this will only remain on the paper and it won't give the benefit what was required out of this proposed amendment in section 10, because no electronic commerce operator will take this headache of all such things. So that is what I feel from this proposed amendment. Now, another amendment has been proposed in section 132, which provides for the imprisonment provisions, right? We have seen day in and day out that there are number of assesses, they are giving in the newspaper that they have caught the person with a 40 crore fake invoices and all such things. How these numbers they are computing, we don't know. They are for a one supply of 5 crores. They are computing for all the suppliers 5 crore. Then he has supplied for a 6 crore. Then it becomes a not 1 crore, but it becomes a 11 crore. So likewise, they are computing the figures, and then they are giving that yes, there is a evasion of 40 crores, 140 crores, and so on. And in many of the cases, we have seen that they are also taking the penal action against the professionals as well, right? So that is also giving them a much more power. So in this, they have proposed for discriminalization of the offenses. One is with respect to the obstruction or prevents an officer in discharge of his duties, which has been generally invoked when he feels that there is an ego issue or something like that. It has been invoked. The one who tampers with or destroys any material or evidences or document. So that has been done away. For these offenses, there cannot be a criminal prosecution. So this is a good thing. Now, however, out of this, the main question arises over here is generally during the imprisonment, what happens that they don't give you the FIR, right? Have you seen they have prepared the FIR? Nobody has prepared. Panchnama just, right? They are preparing a Panchnama. They are not issuing a show cause notice. So main issue remains over here is that can they go for the penal provisions for the imprisonment without an FIR or SCN, which is pending before the Honorable Supreme Court in the case of Sapna Jain. So 3-member bench, it is pending before the Supreme Court. So let us see, apart from this, that what are the amendment has been proposed as far as discriminalization of provisions are concerned in this finance bill. So friends, they have also, for the fake invoices, they have also increased the limit from the 10 million to 20 million. So that is also the limit has been increased. So those are with respect to the, we can say that from this move, we can expect that what government was previously anticipating, that fake invoicing racket is going on, that they might have felt that it is getting reduced. Otherwise, they would not have come out with such proposals. So that is one way of looking into this. Now, another amendment has also been proposed as far as compounding of offenses are concerned, where it says that compounding of offenses shall be added for the acquisition or possession of any goods liable for confiscation, receipt or association in any manner with a supply which is made in contravention of GST laws, or attempt to commit or abatement in commission of an offense which is liable for prosecution under section 132, and issuance of fake invoice leading to availment of utilization of ITC. So this has been added in the compounding of offenses, and therefore the offenses in connection with the issuance of the fake invoice without supply has been explicitly disallowed with this proposed amendment. So that is as far as compounding of offense is concerned, which is also a good step towards this. And yes, this limit has been, minimum limit has been reduced to 25% of the tax involved, and maximum limit is up to 100%. That is also proposed, which was not there. Now, yes, just a minute. One more new section has been proposed to be inserted for consent-based sharing of the information. Friends, we have seen in number of cases that notice has been issued to the registered taxpayer based on the returns which he has filed for the TDS, which he has filed under the income tax, or third party has filed for that particular taxpayer. So to make all such things legalized, they are trying to introduce this new section where they are saying that information will be shared as far as registration details are concerned, written filing details are concerned, and all such various details what you are providing to the GSTN portal, or what portal is getting from the third party, will be used for sharing of the information with GST authorities or with other authorities as well. So now data sharing will be done by this provision. Of course, till now also they were doing, but it has been made in the act itself. So the question arises, friends, when this happens, when you are getting a notice based on the information which has been supplied on some other portal, can you say that yes, you need to accept it? Friends, in my view, it will be still be a litigative area, because when you are getting a notice based on the information which has been submitted in other statute, you cannot directly issue the notice based on that thing, because while issuing the notice, you need to make your independent observation as a tax officer, and according to that, you need to form your allegations for issuance of the notice. You cannot merely rely on that analysis and directly issue the show cause notice or anything. So that will still be remain as a litigative area. So that is one thing. Now, another amendment which has been proposed, which has been made retrospective. Now, friends, paragraph 7 and 8 was introduced in schedule 3, which provides for the activities or transactions which is neither to be treated as supply of goods or supply of services. So now what has been, when it was introduced as a prospective amendment. So department is still issuing the notices for the prior period, that even if there is a high seas sale or out and out sale or supply from the bonded warehouse, they are saying that it is a prospective amendment and it is not a clarificatory in nature, and therefore for the prior period you are liable for the payment of taxes. So now in this finance bill, it has been proposed that paragraph 7 and 8 is to be considered as a retrospective amendment, and therefore it will help to a greater extent to all those assessees who are getting a notice and who are in the litigation for such issues. Yes. Now, friends, we are coming on to the proposals which has been made in the IGST. There are amendment has been proposed in the definition where it says that non-taxable online recipient has been proposed to be amended, where it will be read as non-taxable online recipient means any unregistered person receiving online information and database access or retrieval services located in the taxable territory. An unregistered person includes a person registered solely in terms of section clause 6 of section 24, which is provides for the compulsory registration for the online OIDA. So friends, it says that any unregistered person receiving online information and database access or retrieval service located in the taxable territory. Now, another online information and database access retrieval services has also been proposed to be amended, where it says that the clause essentially automated and involving minimal human intervention shall be removed. Friends, whenever this issue of OIDA was coming, always it becomes a very thin line and interpretational issue that how far human intervention is to be considered as it is a minimal intervention. And there are a lot of litigation is also going on. Department is saying that no, it is not a minimal human intervention. And you are saying that yes, it is a very minimal human intervention. Now, to come out of such litigation areas, they have proposed to delete this phrase itself. So all the online information and database access or retrieval services will get covered into it, irrespective of the human intervention involved into it. So whatever has been provided in this, advertising on internet, providing on cloud service, all such will be considered as online information and database access or retrieval services. So the scope of this service has becoming widened by this proposed amendment. So one has to be very much cautious once it gets introduced. And another thing is that if a non-taxable online recipient, if you are receiving the services from a non-taxable online recipient, then tax is to be paid by that non-taxable online recipient, correct? But if he doesn't make the tax payment, then liability will arise on you, right? So when this getting widened, this both the areas, for the assessees, it becomes very important to get a declaration from the non-taxable online recipient that he has discharged the tax liability. Otherwise, tomorrow, after 2 years, 3 years down the line, it will be very difficult to substantiate that no, he has discharged the tax liability considering himself as the non-taxable online recipient. So it is advisable to obtain a declaration for such type of situation. And now this is a long story which has come to an end. Previously, when GST was introduced, it was only clause 8 under section 12, where they said that registered person shall be the location of that such person, and if a person is other than registered, then shall be the location at which the goods are handed over for such transportation. Thereafter, they inserted a proviso which created more ambiguity. Then to overcome that, recently they issued circular explaining everything in a detailed manner that how it is to be considered for the transportation of goods. So even after that circular was not in line with the provisions. So therefore, again, what proviso they have inserted, in this finance bill, they have proposed to delete that proviso, which was not at all required. So now that ambiguity has come to an end as far as transportation of goods are concerned. So this is a big relief to the industry. Now, friends, with this, we have finished with the amendment what has been proposed in relation to GST. Now, in the customs, there are 2-3 amendments what I would like to highlight. That there are conditional exemptions which were introduced in Finance Bill 2021 for a period of 2 years, that those exemptions will be valid for a period of 2 years. So that was the first time which was introduced, and the intent was that to reduce and to resign the exemptions which are not in use under the customs. That was the main intent. So now there were many ambiguity were going on that now after this end of 2 years, will all those conditional exemptions will go away? So in the last TRU in Finance Bill 2022, it was mentioned that no, it will remain continue. But there was no backing in the statute. It was there in the TRU. So now in this finance bill, they have made it explicitly that no, all such conditional exemptions will remain in force. So that has been proposed, that was very much needed. But friends, another thought which is coming up in my mind, that what will happen if up to 31st March, bill doesn't get the assent of the president? Then only one option remains, that if it doesn't get the assent of the president, then all those notifications needs to be amended. Then they have to amend those notification and extend the timeline. That is the only option available with them. That is what I believe as far as that is concerned. And one more I would like to discuss, being into, we are the Sales Tax Practitioners Association since beginning. We are aware that this tribunal was not functioning since over a period of 1 year for the CST matters are concerned. So now what they have proposed, that all the CST matters will be heard by the SESTAT, which is the Customs, Excise and Service Tax Appellate Tribunal. So all these matter will be heard by the SESTAT as far as CST matters are concerned. So that is also great relief what has been proposed in the finance bill. Friends, now with this, what are the highlights what I wanted to discuss with you? I have discussed. Now, if you have any issues or any queries, we can have a discussion on that. Yes, sir. हाँ.
So whether it matters because they are already covered under IPC and as per judgment आपने बताया कि किस अंदर है ऑनरेबल सुप्रीम कोर्ट में तो उस हिसाब से अगर वो किया होगा तो इट इज वेलकम स्टेप ना अगर
सर अभी
क्योंकि
स्टिल
because the very first thing is that officer has all the powers of in charge of the police station.
Correct.
Under jurisdiction, huh?
Correct.
So if he has to go to the court of law, then he has to follow the same procedure given in IPC and CIRP.
Correct.
So इधर से निकालना तो ज्यादा फर्क नहीं पड़ेगा बल्कि ऑफिसर गलत फायदा नहीं उठा सकेगा ये अच्छा हो सकता है.
That is the correct intention. That is what we are saying. What I am saying is that when they are not preparing this FIR and SCM, can they go for the penal provisions? Even the another issue remains that in some of the cases where without computation, they are going for the penal consequences. So that issue still remains even after this proposed amendment. So those are the broader areas, even after this amendment. That is this what they have deleted. That is the always good thing. That because what officers are doing, we all are aware that if he is having some ego issues with you, he is also threatening you with this provision that I will also penalize you with this. So all this is a welcome move, what they have done it.
They can start the case but cannot conclude the matter because matter has to be concluded by court only.
By court only. Correct. So that is what is the main issue, that they are not willing to issue the show cause notice, because once the show cause notice is issued, it's over. Litigation start. They are interested in the revenue, spot revenue, we can say. Yes.
What about the implementation of section 62 and section 76? In that case, whether we can file FIR against that particular dealer and party to the nodal officer?
See, sir, how can you say
That's
that?
correction, but not correct. Section 76.
See, that
And
is
section
that
62 casts responsibility on them to monitor
see
the dealer. Yeah.
always when it comes on you, you can always challenge that thing, because that is not under the GST, that is the right which is available with you. So you can always challenge that thing, that if you are saying that I am not entitled to avail the credit, I am not responsible for that. You are also, that officer is also equally responsible. That person is also equally responsible for that. So that you can always challenge. After all, that is to be decided by the court of law, sir. But you can always go for it. Always, sir. Sir, in many of the cases now during the, yes, in many of the cases during the lockdown, what happened? That they used the GSTN number and PAN number, they took the registration. That fellow is not aware that somebody else is doing the business on his PAN and everything. Then this fellow came to know and these cases came to us. We immediately went for the FIR against that person, though we don't know who is the person who is doing all these things. So it is our responsibility, because apart from that, we cannot do anything. Because that shows that my PAN number is there, my address is there, but at that particular location, I am not available. Because they have fraudulently, they have taken this registration. I have not done any business. So depending upon your facts of the case, you can always go for this, sir. This is just one example, added example I have given to you. Yes, sir.
Once you have covered almost all the points of the section, I just want to add the section 132, decriminalization.
There you have mentioned that obstruction and preventing of officer in charge of duty. That is decriminalized. There is two additional marks. Then I will do the slip of deliberate tackling of all the material volumes.
Hmm.
And probably failure to supply information. Because of the point they have decriminalized.
Yes, yes, sir. It is. They have decriminalized that thing. Three things, four things they have decriminalized.
Fourth is, which is the fourth. One is the obstruction, second is the.
Yes, three. G three.
And third, the point, three. Section 78883. If taking retrospective of 1/7/2000.
Correct.
31st January 2019.
Correct.
If the SSC has paid the tax.
Sir, there it specifically says that you are not entitled for the refund. There it specifically says. That is why I told you now for section 23 amendment,
Okay, sir.
it is not explicitly providing that you cannot go for the refund. But here
Okay.
for schedule 3, it is specifically mentioning
Cannot-
that you cannot, no.
That the person who is paid that.
He is, yes, he is.
Thank you very much.
Is there any further questions? Okay, at least there were few queries, so I can say that, okay, you have understood something. Otherwise, when we are not getting any questions, I feel that nobody has understood anything. Okay. Okay, so thank you so much. I am thankful to the association for giving me an opportunity to speak on my views on this important topic of budget proposals, as very few are getting this opportunity to speak on the study circles. So I am thankful to the association for giving me an opportunity. Thank you. Thank you so much.
Thank you, Monarch Bhatt, for the wonderful explanation of the budget analysis relating to indirect tax. Now, before we proceed to the formal vote of thanks, I would thank each and everyone who is present over here for making their time out and coming for the study circle meeting, and also people who are there online. But I think after COVID, we all have got this habit of watching or listening to people only on online basis and not being physically present. And somehow I think that is hampering development of law, I would say, because unless until we are physically present and debate on certain things, there may not be a good point coming out of the discussion. So I'll request everybody who is there online that kindly make yourself available in the library physically, personally, and a personal interaction with the speaker as well as with the other members would encourage more and more healthy discussion, and the speakers also feel very charged and rejuvenated for the next topic. And now coming to the vote of thanks, Monarch Bhatt, thank you so much for giving your time in this tough times, I would say. And it is indeed our, we can say that our, I'm missing the word, but thank you so much for giving us this time of yours and enlightening us on the various financial implications of this budget relating to indirect taxes. I would now request everybody to give a loud round of applause for Monarch Bhatt. And now we raise for the national anthem. Yeah.